Thank you, Teresa. I am now going to talk about HUD's fair housing role and the fair housing laws that HUD enforces. So HUD's Office of Fair Housing and Equal Opportunity, or FHEO, has an overall mission to promote equal housing opportunity. We do this in several ways. First of all, by administratively enforcing federal fair housing laws. We do this by monitoring recipients of HUD funding, like public housing authorities and local jurisdictions, for compliance with federal fair housing laws and civil rights requirements. And we do this by training and educating housing consumers and providers on fair housing rights and responsibilities. And finally, we do this by funding and monitoring state, local, and nonprofit fair housing organizations through our Fair Housing Assistance Program, or FAP, and our Fair Housing Initiatives Program, or FIP. We have 3 branches in FHEO. We have an intake branch, which helps people file housing discrimination complaints. And we have, I think, a couple of HUD intake staff here. Is Paul Smith here, our intake branch chief? Okay, no. But I think Laura Uribe is here. Laura, can you stand up? I just want to introduce HUD staff. So she's from our intake branch. Anybody else from the intake branch here? Okay, our enforcement branch investigates and conciliates HUD-filed housing discrimination complaints. And our acting enforcement branch chief is here, Kath Ross Perry. Could you stand up, please? And I think Janice McConico is here from our enforcement branch. Sue Sheftel is here. Sue Sheftel, who used to be at DFEH, actually. Lolinda Portlock is here. And our program compliance branch, the famous Jeff Jackson. Oh, and yes, I'm sorry, our enforcement branch is also joined today by our investigators, Greg Crespo and Jamie Rodney. Anybody else from the enforcement branch that I missed? Okay, and Jeff, finally. Roz is from our intake branch. Rosalind Evans. And then finally, Jeff Jackson, he's our program compliance branch chief. And from that branch, we have Adriana Wyndham here. And I think that's it from the program compliance branch. So there's your HUD staff. We have a lot of HUD people here today as resources for you if you have questions throughout the day. So here in Marin, we are based in HUD Region 9. And HUD Region 9 covers California, Nevada, Arizona, Hawaii, Guam, and American Samoa. Many of the housing discrimination complaints that HUD takes in Region 9 are referred for investigation to agencies that enforce state and local fair housing laws that HUD has deemed substantially equivalent to the Federal Fair Housing Act. So if the complaint arose in California, for example, we would likely refer that complaint to DFEH, Teresa's agency, because DFEH is HUD's substantially equivalent agency in California. Now, if a complaint arose in Arizona or Hawaii, we would also likely refer that complaint to the substantially equivalent agencies in those states. Now, even with those referrals, HUD Region 9 still investigates about 300 complaints of housing discrimination per year. Many of these complaints arise in Nevada, which does not have a substantially equivalent agency. In addition, consistent with agreements that we have with our substantially equivalent agencies, HUD may retain certain types of complaints and not refer them to the substantially equivalent agencies. For example, HUD may retain and investigate complaints that are systemic in nature, meaning cases that affect a large number of people. We might retain cases like that. We may retain complaints that raise novel or complex issues of fact or law. And we may retain complaints that involve a recipient of HUD funding. And on this last category, HUD enforces federal civil rights laws that only apply to recipients of HUD funding. And on certain issues, these laws may actually provide greater protection to individuals than the substantially equivalent state or local laws, which is why HUD may keep and not refer complaints that involve recipients of HUD funding. And I'll talk a little bit more about those specific civil rights laws that only apply to recipients of HUD funding in a few minutes. But now I'm going to talk about sort of the main federal law that prohibits housing discrimination, and that is the Fair Housing Act. I'm not going to go into a lot of depth about the Fair Housing Act because Teresa talked about FHEO, the California Fair Employment and Housing Act, and the other California fair housing laws. And FHEO largely mirrors the Fair Housing Act because it is substantially equivalent. Now, the Fair Housing Act includes 7 protected classes: race, color, national origin, religion, sex, disability, and familial status. All of those protected classes are included in California law. However, as you can see, not all of the protected classes in California law are actually enumerated in the Fair Housing Act. The Fair Housing Act does not enumerate source of income, it doesn't enumerate age, and it doesn't enumerate genetic information as protected classes. Now, with regard to sexual orientation and gender identity and marital status, you can see that those classes are also not listed in the Fair Housing Act. However, with regard to HUD-funded housing, HUD published a regulation in 2012 requiring recipients of HUD funding to make housing available without regard to sexual orientation, gender identity, and marital status. In addition, HUD interprets its prohibition of sex discrimination to include discrimination because of nonconformity with gender stereotypes, which is essentially gender identity or gender expression discrimination. Now, the Fair Housing Act prohibits similar activities that are prohibited in FHEO. For example, refusing to rent or sell based on protected classes, implementing different terms and conditions based on protected classes, misrepresenting the availability of housing because of a protected class, advertising or making discriminatory statements with respect to the rental sale of a dwelling. Those are all prohibited in the Fair Housing Act, and there's several other prohibited activities. The Fair Housing Act applies to the vast majority of housing providers, whether they receive HUD funding or not. But the Fair Housing Act does have exemptions. We have sort of an exemption involving boarding house situations where the owner resides in the house and rents rooms in the house to 4 or fewer tenants. The Fair Housing Act also has a religious organization exemption, which allows non-commercial housing that's operated by a religious organization to be limited to people of that particular religion. So a monastery would be an example of that. We also have a senior exemption. We have a few other exemptions very similar to FHEO. That's all I'm going to say about the Fair Housing Act, other than just to highlight Section 808E5, which states that the Secretary of Housing and Urban Development shall administer programs and activities relating to housing and urban development in a manner affirmatively to further the policies of this title. And we're going to be talking a lot more about that provision throughout the day today. So I'll now shift gears and talk about those civil rights laws that only apply to recipients of HUD funding. Recipients of HUD funding include, for example, public housing authorities, jurisdictions that receive HUD funding from HUD Community Development Block Grants, housing that receives funding from other HUD programs like COPA, which is Housing Opportunities for People with AIDS, our Section 202811 programs, all housing that receives any federal funding. These laws will apply to those housing providers. Now, when HUD funds pass through or pass from a recipient like a jurisdiction that receives CDBG funds, Community Development Block Grant funds, and it passes to a subrecipient like a nonprofit housing agency, that subrecipient would also have to comply with these laws. So these laws apply to both recipients and subrecipients. And over the next few minutes, I'll just be referring to recipients, but you can surmise that we're also talking about subrecipients. Receipt of Section 8?
Section 8 vouchers and people who are on the waiting list, yes.
It includes the housing authority that's administering the Section 8 program. It does apply to, but the private landlord who's receiving the Section 8 voucher does not apply to them. So the first law I'm going to be talking about that applies to recipients of HUD funding is Title VI of the Civil Rights Act of 1964. Title VI prohibits recipients of HUD funding from discriminating on the basis of or using methods of administration that have the effect of limiting or denying participation on the basis of race, color, or national origin. So Title VI prohibits recipients from intentionally discriminating against someone on the basis of race, color, and national origin. Title VI also prohibits recipients from administering their programs in a manner that has the effect of limiting or denying participation on the basis of race, color, or national origin, even though the intent may not be there. An example of a recipient administering programs in a manner that has the effect of discriminating in violation of Title VI would involve not taking reasonable steps to ensure meaningful access of persons who, because of their national origin, are limited English proficient or LEP. HUD has developed guidance for its recipients on what taking reasonable steps to ensure meaningful access means, including a requirement that recipients conduct what we call a four-factor analysis to determine their scope of obligations in regards to serving people who are LEP. And this slide lists what those four factors are that need to be considered. So when we're talking about language access, we're typically talking about either an applicant or a beneficiary's need for oral interpretation or an applicant or beneficiary's need for written translations. HUD guidance sets forth requirements related to oral interpretation, and essentially oral interpretation is always required. It just depends how a recipient would maybe provide that oral interpretation, whether it's use of staff or use of a language line. And it's important to remember that recipients should not require LEP persons to bring their own interpreter, and a recipient should also not rely on family members or friends of the LEP person for interpretation. Now, this slide deals with the written translation piece. HUD guidelines establish what we call a, quote, safe harbor of presumptive compliance. And this slide identifies what that is. And for the sake of time, I'm not going to go into details of that. You have the slide, and you can talk to us later if you have questions about what is involved in the safe harbor. Now, after completing the four-factor analysis and deciding what language assistance services are appropriate, HUD encourages recipients to develop a language access plan, and this slide lists components of an effective language access plan. And finally, these are some LEP resources. We have some really great sort of FAQs, Q&As online that sort of put our 2007 HUD LEP guidance in plain English. That's the first link there, and then our actual HUD LEP guidance. That is the second link that you can go to get further information on LEP. So the next civil rights law to mention that applies to recipients of HUD funds is Section 504 of the Rehabilitation Act of 1973. The language in the Section 504 regulation is similar to the language in the Title VI regulation. Section 504 prohibits recipients from discriminating on the basis of or using methods of administration that have the effect of limiting or denying participation on the basis of disability. And disability includes physical, mental, or developmental disabilities. HUD regulations have Section 504 requirements that apply to our recipients, which this slide lists. We have a requirement for effective communication, such as providing auxiliary aids when necessary to provide a person with a disability the equal opportunity to participate in the program. Now, the Section 504 coordinator, public notice of non-discrimination requirement, and disability grievance policy and procedure, those are actually only required of recipients that employ 15 or more people. Section 504 also has physical accessibility requirements that apply to new construction, multifamily projects of 5 or more units. I'm not going to go into depth on that. You can look at the slide and ask us questions later if you'd like to learn more. And finally, one thing I did want to spend a couple minutes talking about is sort of this idea of reasonable modifications under Section 504. Now, like FHEO and the Fair Housing Act, Section 504 prohibits or provides for the right to reasonable accommodations. However, with this slide, I wanted to point out an important difference between FHEO, the Fair Housing Act, and Section 504. As Teresa talked about, reasonable modifications, which are structural changes made to a unit because of the needs of a person with a disability, are generally for the tenant to pay for under FHEO. And that's generally the case under the Fair Housing Act as well. Now, in contrast, under Section 504, the federally funded housing provider, not the tenant, generally bears the financial obligation to make structural changes needed because of a disability. Under Section 504, structural changes needed by an applicant or a resident because of that applicant or resident's disability are actually considered reasonable accommodations, and they must be paid for by the housing provider unless providing it would be an undue financial and administrative burden, or the housing provider can accommodate through other means. So these are a couple of other laws that HUD FHEO enforces. I'm not going to talk about those at the moment. I'm actually going to go to the next slide because I have only a couple more minutes left. Carolyn actually asked us to talk about matters of regional concern. So I'll mention a couple of very recent complaints based here in Marin that HUD received, investigated, and resolved. One involved a homeless man who filed a complaint with HUD alleging that a shelter denied his reasonable accommodation request. The man had mental disabilities, and he asked the shelter that his emotional support dog be allowed to stay with him in the shelter as a reasonable accommodation. The shelter initially denied this request out of concern for others at the shelter who may be allergic to dogs or might be afraid of dogs. The shelter is funded in part by HUD. So HUD ended up taking this complaint, and we investigated it under both the Fair Housing Act as well as Section 504. Now, prior to HUD determining whether there was sufficient evidence that these laws had been violated, Fair Housing Act Section 504, the parties agreed to conciliate. The Conciliation and Voluntary Compliance Agreement was executed just this past November. And as part of the agreement, the agency that runs the shelter agreed to reasonably accommodate people who need emotional support animals in the future. The agency also agreed to be trained on HUD compliance with fair housing laws. The agency agreed to hire a Section 504 coordinator and institute a Section 504 grievance policy. And finally, the agency that runs the shelter agreed to enter into a lease with the man for a studio unit at its long-term transitional housing facility, where his rent would be subsidized for the period of the lease, and the man's dog would be allowed to reside with him. So that's one case that we've recently handled. Another recent matter here in Marin actually involved Fair Housing of Marin, the organization that has put on this event today. And that complaint involved 5 complaints, actually. It was a number of individuals who alleged discrimination. And they were African American and Latino, and they alleged race and national origin discrimination when they attempted to rent apartments at a building here in San Rafael. A fair housing group, Fair Housing of Marin, conducted 3 paired fair housing tests of this housing provider. And that involved sending African American, Latino, and white individuals posed as prospective tenants to the building and comparing the treatment of these individuals. The Fair Housing Group alleged that the tests corroborated that African American and Latino applicants were treated unfairly as compared to whites, and that they were discouraged from applying for units. They were falsely informed that units were not available. They were quoted higher move-in costs, and they were not provided paper or electronic applications. Prior to HUD determining whether there was sufficient evidence in this case, the matter also settled, it conciliated. As part of the HUD-executed conciliation agreement, the owners and property management company agreed to obtain fair housing training and pay $2,000 or $2,500 to each of the 5 complainants individually, as well as $6,500 to Fair Housing of Marin for its diversion of resources and its frustration of mission. So So those are a couple of cases. You'll see a common thread in these conciliations, and this is true for most HUD conciliations, and that is training. We almost always try to secure public interest relief in the form of the respondent, the recipient, getting fair housing training. And we can't emphasize that enough to ensure compliance. It's incredibly important for anyone subject to the fair housing laws to get fair housing training for themselves and their staff. And finally, just to sort of segue into the rest of today, on December 21st, 2010, HUD and Marin County executed a voluntary compliance agreement, and this VCA resolved findings of civil rights noncompliance, including related to the Fair Housing Act's mandate to affirmatively further fair housing. And I'm not going to go into further detail on this right now. It'll probably be discussed throughout the rest of today. So thank you.